Sure. All right, I'd like to call the policy committee meeting to order at 6:30. So we're going to start with the policies for rescission. And everyone should have in their packet the policy summary that was reviewed by Chipman and Goodwin. So the first policy is 9220.6 board candidates. Chipman and Goodwin feel that this bylaw is not required and they recommend repeal. Essentially, we don't have the authority as a board to dictate requirements for potential board members. And most, if not all, of the information included in this particular policy is available on the board website, so they recommend to rescind it. Is there any discussion about this? I figure we'll just go through all the policies for rescission and then vote as a group to rescind it again. So the next policy then is 9500 school board meetings. Chipman and Goodwin recommend repeal and replacement with their model bylaw meeting conduct, which we already did. That's policy 9540.10, which was approved on June 20th. Therefore, this policy is no longer needed because it's already covered by 9540.10. So they recommend rescind. Any comments, questions? Okay, the next policy is 9540.4 rules of order. This is not necessary because we use Robert's Rules of Order, which is also addressed in our model bylaw, the meeting conduct 9540.10, which was approved on June 20th. So this is no longer needed. Recommend to rescind. Questions, comments? Okay, moving on. Policy 9400, organization of school boards. They recommend repeal of this and adopting the model bylaw officers and the duties for chairperson, vice chairperson, secretary. We already adopted officers policy 9420 and vacancies. 9220.3 filling vacancies on the board. They were adopted the August 22nd Board of Ed meeting. Therefore, this policy 9400 is obsolete. It's no longer needed. Any comments or questions? The next policy for rescission is 9410 board organizational meeting. Chipman and Goodwin recommend repeal and replace with the model bylaw officers, which we already adopted at the Board of Ed meeting on August 22nd. Therefore, this policy is no longer needed because it's already covered. So policies 9220.6 board candidates, 9500 school board meetings, 9540.4 rules of order, 9400 organization of school board, and 9410 board organizational meeting. I need a motion to recommend to the board to rescind these policies. So moved.
Second.
You all in favor?
Aye.
All right. Well, that was fast. Okay. So now we're moving on to rescind and replace. So the first policy, you should have gotten a new copy of policy 1370 non-discrimination. This is under community school relations. You can go through and see where the changes were made. If you look at your policy summary, Chipman and Goodwin revised all of the non-discrimination policies, which is community school relations and the 1000 series and the personnel in the 4000 series and the students in the 5000 series. For technical revisions, they added definitions of discrimination and harassment and included examples of the types of conduct that may be considered protected class harassment prohibited by the policy. These revisions were designed to provide guidance to districts in determining whether conduct in question constitutes discrimination or harassment. And also there was Public Act 2282 that we had to add domestic violence victims as a protected class under Connecticut's anti-discrimination laws. So all the changes here that were made were to reflect changes in Connecticut general statutes and to make sure that we're compliant with laws and updated definitions. So these are three policies that we're looking at. 1370 non-discrimination under community school relations, 4118.1 non-discrimination under personnel, and 5020.1 non-discrimination under students. They all have the same changes. Does anyone have any comments or questions regarding the changes in these policies? Yes.
So I completely agree. I'm not a lawyer. I completely agree with the intent and everything. I do have a question about the language This would be in lines 48 through 54. Where it says that,
Under harassment,
yes,
are you looking at, I'm sorry, which policy you?
this is 1370.
1370, sorry.
Yeah, and again, I agree with the intent, what they're trying to do, but I have a question where it says graphic, written, or electronic communication that are harmful or humiliating based on protecting class membership. That's determined by whom? Harmful is determined by whom? And then the second aspect of that is lines 53 through 54, harassment does not have to include intent to harm. Be directed at a specific target or involve repeated incidents. And once again, I
So
generally agree, but
just to clarify, I'm not sure if you're looking at the old version or the new version, because the line graphic, written, or electronic communications that are harmful or humiliating, that is line 53 and 54.
Mhm.
Okay, and then the harassment does not have to include the intent to harm, that's 58, 59.
right.
Okay, thank you.
So I realize that the enforcement of these things requires judgment, by the administration, circumstances, all of that. But that's kind of odd.
I agree with you, yeah.
If I say something like,
I think that that's how it's written in the statute, and that's why it's written here. And there was some other wording that I had asked about as well that I wanted to change, but it's written that way in the statute. And therefore it isn't language that we can change. But is that,
That's correct, because when I reached out to the attorney to ask about the one that you said, they said basically, even if we changed it in the policy, if this was brought forward in like a CHRO investigation or anything like that, they will automatically jump to the language in the statute, so it wouldn't look good for ours not to match.
so the definition, or not definition, but the sentence where it says graphic, written, or electronic communications that are harmful or humiliating based on protected class membership, do you know if that's straight from the statute?
Yes,
It is.
the definitions are all pulled directly from the statute, so that's where they said you do have some flexibility when you do these sorts of policies, but when it comes to definitions pulled directly from law, they do not want you to wiggle around with that.
Well, how would we handle that kind if it did come up as an issue?
I think it's like many of our policies, whether it's bullying or student discipline, we're making professional judgment based on that. We're often consulting with an attorney when you get into this specific type of situation as well. But that's consistent with changes we've seen in case law and student issues too. And so it doesn't necessarily have to be the intent to harm, but it's more the impact. Yeah.
right, but I mean, to take it to a logical extreme, which is probably a bad idea. If somebody is has schizophrenia or is mentally ill and sincerely believes that they were harmed by something, then they could have a case.
So then I think we look at, the reasonable person standard, reasonable people, so we look at that, again, with consult with legal, that there are times when it's found not to be the case, with go back to bullying too, like we talked about that, when there are times with students where it's mean behavior, but it's not bullying, or it's something that we need some corrective action on, but it's not bullying. So I think that could be something along those lines.
Yeah, it's difficult because it is very broad.
I mean, in my opinion, I think then that the statute is probably written too broad,
Yeah.
but there's nothing we can do about that at this level. So we're just complying. Is there anything, any other questions or?
There is actually,
Okay.
since I'm just skunk in the garden party right now. It's 42, still at 1370 non-discrimination. Lines 42 through 44, let's say, to 45. And again, I agree with the intent, nobody wants to discriminate. Okay, objectively offensive racial, ethnic, or religious epithets. How would we handle Huck Finn versus Analyzing a Hip Hop Song?
Right.
I was hoping someone else would take that.
That's it over you. I mean, I don't disagree with you, Galen, I completely agree with you.
I mean, it's analysis of text, both cases.
Well, but that's, those in both cases are academic pursuits. Whereas, and I'm not advocating that these be taught in a way that is, in any way insensitive. What this is really intended to get at is discrimination of, board members, students, employees, against people. So it's like if you're calling someone a name, name calling as opposed to teaching that in an historical context, Huck Finn.
But if that's not
That's
your,
an insensitive
if that's not your intent, and I feel harmed. Then,
So I think it'd be the
Correct.
conduct of the person, so if someone was playing music at lunchtime. Every day at lunch, they want to put music on or something like that, and someone was feeling uncomfortable because of that. Then I think that would get to, it's not an intent. It'd probably just be told not to play music, or to read Huck Finn out loud and it's offensive to somebody, or somebody doesn't want to hear that. I think that's how those types of situations would be handled.
Well, also, I would just draw attention that this particular policy that you're referring to is under community school relations. But what you're describing would really be under the student
Okay,
5,000
yeah, fair point.
series.
same, but it's the same.
But it is the
language.
same wording.
Yeah,
Yes, it's exactly the same wording. These are all, nearly identical. All the wording comes from the same statutes. And I mean, when I was first reading through it, I found a lot of the definitions a little vague, a little subjective. But when I asked her to look it up, she's like, she checked with Shipman and Goodwin, and they said that the language is directly from the statute, and therefore it should remain.
Is there something we could add though to?
so this is one area, it's kind of goes back to what Zoe was sharing, that most likely all 169 school districts in Connecticut are gonna have pretty much the same language, because that is the legal definition. So if we start adding or subtracting, I think we're going down a slippery slope of like setting ourselves up. You ever take something out of like I've had this question posed to me before, not here, but of the protected class list, like I've had somebody ask why when we take this out, the answer is no, because then you're signifying, we know that it's updated, but we're specifically saying we're not going to make that a protected class, we're not gonna recognize that as a
Even so, I
protected
think
class.
go straight to the statute and put the
Right.
language over there, and that's what it would base there.
And I just wonder, question, just out of curiosity, what is alienage? When they say that we will not discriminate by race, religion, color, national origin, ancestry, alienage.
That's the status of your documentation of your immigration and.
Like a resident
naturalization
alien.
status.
Okay, all right.
But that was actually removed, the term alienage. You're talking about line 63.
Well,
Because line 61 is sexual harassment is a form of harassment. And
Right.
it goes on, and then what's crossed out is marital status, national origin, ancestry, alienage, disability.
well, in the opening paragraph of 1370 is the policy of the Board of Education, that any form.
Oh, I
of
see, it's still there.
Still there.
Okay.
The other thing is, as a policy, non-discrimination kind of guides our organization as to what's tolerated and what's permissible and what's not. This is not necessarily, I mean, yes, someone can use our policies that we maintain as evidence of negligence if we don't enforce them. But the basis for the discrimination is not our policy, it's the statute anyway. So, and on top of that, so within that scheme, having a non-discrimination policy that's based on the statute allows us really some wiggle room to be able to discern whether there was unintentional conduct that we can kind of nip in the bud or find a way to explain if someone was being insensitive. And they're not, it's not automatically a lawsuit.
Okay, are there any other questions or comments regarding policies 1370, 4118.1, and 5020.1 discrimination? So, can I have a motion then to move this forward to the board with recommendation for rescinding the place?
Hell, yes, I'm sorry.
And second, all in favor?
Yeah.
All right. Next on the list is 4030.5. Oh, I don't know if you saw in your packet, the administrative regulations regarding 1370 and 4118.1. They had the same changes to them. We don't vote on regulations, but if we didn't like the way the regulation was written, we can request that the clerk to change it. But it's the same changes as the policies. If there are no questions about the regulations, then we'll move on to 4030.5 FMLA, family and medical leave. So you should have a copy of the current policy, which is very short. And then you should have copy of the revised policy, which is not short.
Yeah.
Were there any questions or comments regarding this particular policy about FMLA? So I'll just tell you the question that I had. So if you looked at line 210, where it says both spouses working for the same employer, I questioned that because if you were like, just one employee, you would get the full 12 weeks within the 12-month entitlement period. But if both spouses work for the same employer, they get a combined 12 weeks and not 12 weeks each. And so I questioned that because I thought it seemed kind of unfair, but apparently that is law and there's nothing we can do about that. But other than that, I didn't have any other questions or comments on this policy. Does anybody else? All right, so then we would like to recommend, did you want to say something?
Well, this is just a general question. I hope it's out of bounds. Would our personnel department take a look at this? So with Heather,
Yeah,
Heather looks at it.
it's consistent.
right, okay.
One question I have is, sometimes Shipman and Goodwin takes the position that we should just use a general policy that refers to the statute. Why are they recommending that we have a long policy that incorporates the statute in this case, instead of just referencing the statute? Because then, this is some really seriously legalistic stuff.
Yeah, I don't know.
They go even further, the law goes even further with family medical leave, that we have to post this and send it out periodically to employees, and it's every 6 months that Heather has to send it out to our email system. I think because they want it described for employees as accessible, so they know their FMLA rights.
But they could just say, post the statute too. But this is deemed to be an easier version.
Yeah, it works, right, and then, I'm not sure exactly where it is in the statute, but for instance, like the school paraprofessionals, that's a relatively new piece of FMLA where what had happened before was they were never scheduled for 1,250 hours of work. So paraprofessionals weren't able to access FMLA, so they appealed to the legislature in Connecticut, so it's 950 hours, service hours, which is more closely reflective of working there for a paraprofessional. So that's an example of, I think it's clearly defined in our policy, whereas the reg, I haven't looked at it recently, but that might not be as clearly spelled out.
This isn't a policy question per se, but I don't know enough to evaluate this. Does this have a meaningful impact on our operations or our budget or anything like that?
It does quite significantly in terms of typically lost time, not so much of budget, but you know, that somebody could take time off to care for a spouse and an educational, a parent, which we want to support it. I think that's a good thing, but it does have the impact of losing that teacher or staff member for a significant amount of time during a school year where we can't always find a physics teacher to fill in for or something like that. I'll just use an example.
And is this different enough from the previous iteration? of
No,
policy?
no,
Okay,
this-
so
this-
there's nothing new here that
You won't notice any different.
Okay.
This happened in 1993.
Okay,
Yes.
all right, good, thanks.
I mean, I think it would have budgetary consequences if we have to keep. bringing
Because
in-
most of our staff have sick time, that's where, you know, they would have been able to do this anyway, prior to then. But I think, you know, a lot of ways it was meant for, private employers, but with sick time for our situation and employees having up to 180 days of sick time. A lot of times it's more of an impact to us than it would be.
Because we still have to pay for a sub, if we can find a sub in that particular deal.
Yeah.
And then we also have to, you know, pay the sub while we're paying the sick leave.
Yep.
But just to be clear, FMLA doesn't require pay, but it does allow them to use their sick leave if they have it accrued.
If it's for their personal illness or if
Yeah.
they're within a, you know, certain time frame, but yeah.
And then, how does that work with contributions to the teacher's pension?
They're when a teacher's using sick time or whatever, they still pay out because they get full pay for that.
Okay, thank you.
Anything else regarding FMLA? Can we vote to rescind and replace, and do you recommend to the board?
I'll second.
All fair?
Aye.
All right, policy 4160, student activity / transportation vehicles. There's just minimal changes to this policy. Essentially this change, is for, pronouns to nouns, essentially. Any discussion or questions or comments on 4160? Can we vote to move this forward? All in favor? Aye, thanks. Right. Next policy is 4111.1, security checks / fingerprinting, formerly called reference checks. So this one, let's see. Shipman and Goodwin, that the state law prohibits employers from requiring applicants and employees to disclose the existence of erased criminal history information. Effective January 1 of 2023, the definition of erased records has been expanded. In addition, the Connecticut general statutes require that employment applications that contain a question concerning criminal history of the applicant also has to contain specific notice in clear and conspicuous language. So they have revised our model policy to identify this notice requirement and include the required notice language. So essentially, this is just making sure that we are compliant with Connecticut general statutes. Does anyone have any questions or comments regarding the changes in policy 4111.1? Essentially, we can't do anything about the changes, so. Can we have a motion to move this forward for rescind and replace? So moved.
I'll second.
All in favor?
Aye.
Aye. Thank you. All right, 4112.8. / 4212.8 nepotism. And you can find a copy of our current policy, and then you'll find a copy of the revised policy. Shipman and Goodwin recommends that we repeal our current policy and replace with the revised policy. So we had previously discussed this quite some time ago. We had some discussion about wording, how to make it not as strict, but kind of hard to do that. So I'm sure you read policy that was revised. Are there any questions or comments regarding the changes that were made? if you remember, we were previously discussing about, if there was a position that was very, very specific. That under normal circumstances, you would find it difficult to fill that position. And then, if there was a relation to a current employee of how that would work. And we didn't really come up with any sort of fix for that. Essentially, you really can't have them be a immediate supervisor or anything like that. But there is some language in here that allows the superintendent some leeway with certain things, so. Any questions or comments regarding the changes?
Things like you said, Frank, are you comfortable with where this landed?
I am, yeah, we had some interesting conversation about it and at this table, and so, but I think the ultimate piece is the board could waive it. So if we ever were in a situation where I felt it was necessary or a good idea, I could bring it to the board and ask the board to waive this policy for purposes of hiring an individual or something like that. So I think that that's always a safeguard if we ever need to.
And that goes for any policy.
Right.
Yeah, it also leaves some wiggle room for, to craft the result where you can bring them in, but you move someone around so that they're not in the direct chain of supervision.
I think it's like a very specific circumstance that
Yeah.
you would, if it comes up, that you would be able to figure it out, or whoever is here. If it's not us. All right, so recommendation then, or a motion to move that forward.
So
Second.
All in favor? Aye. Good. I'll just pound right through here.
Wait, was that recommendation to waive readings or just to move it to?
No, I'm
first?
I'm not gonna waive readings.
Yeah, okay,
No.
yeah, okay.
I think there's too many changes.
Yeah.
To
That
waive
that was
readings.
my concern. Yeah,
Yeah.
okay.
Okay. So. Policy 9710, school district logo and or motto. And also, we're gonna talk about these together. 9720 guidelines for use of district logo and board member names. So this is one that we actually are probably not going to figure out tonight. But the one thing that Shipman and Goodwin were definite about was that they do not want 9720. They said the bylaw is not required. They recommend repeal. The bylaw addresses duties of the superintendent rather than the board and is not really appropriate for a bylaw. So you should have gotten a handout tonight with. It says policy 9710 school district logo. And you see this one, it's a different one. Does everyone get this tonight? So these are we were talking about like what should we do with this, and so 9710 as it stands now is outdated and kind of useless, so we would definitely recommend rescinding the current policy of 9710. And then the current policy for 9720 Shipman and Goodwin recommend repealing because it's not really a bylaw. It talks more about like what the superintendent can do or should do, et cetera. And so they recommend repealing that. However, with our current state of talking about changing our mascot logo, not the mascot itself, but the logo, and the fact that we recently changed our school district logo, I felt like we should have some sort of policy in place. One, so that in the future, it's not so easy to just change something willy-nilly just because like you feel like it. But also to have a way to do it. So one of the things that I wanted to have in the policy was some sort of statement that says that the board would always retain final approval for any changes either to the Madison Public School District logo, but also to the athletic logos or mascot logos. And that it would require a 2/3 vote of all the board members. And that way it's not something that's easily changed, but would require definitely a more unanimous vote by the board that is necessary. So in keeping with that, we talked about moving the policy to the 1000 series, because it's not really a bylaw, it doesn't really. Talk about how the board handles our own procedures. So if we move it to the 1000 series, that's more of a community. That's a community series. And also, we wouldn't want to move it into, like, right now we have naming and renaming of schools and school buildings, so that falls under facilities, and so this wouldn't really fall under that either. But I liked the idea of having a definite protocol of how to do it, in the same way that we said for the naming of facilities, that we would form a committee and we would have certain stakeholders, in place so that it's fair and equitable, and that, the superintendent would be a non-voting person, the chair of the board would be a non-voting person, but they would both sit on the committee. And so it's that kind of wording that I'm looking for. So this policy, then, we're proposing to move it to the 1000 series and be 1362. And then we would need to work on the wording of this. So as you can see, there's possible additions to the draft policy. And so this, I think, is something that the committee can discuss about what we think. Do we want it, as formal a procedure as naming a school building? Do we want it less formal? Discussion.
I would think it'd be less formal in naming the building, so that we have a little bit more flexibility.
But I mean, I kind of feel like, when you have a school, not necessarily the district logo, although we just changed that and we didn't go through a whole rigmarole. But I have heard some stakeholders say they didn't like it, and but I feel like if we were to change it, like, there would need to be a good reason to change it. And therefore, I would like to have, something in place that says it's got to be a 2/3 vote of the whole board. But I also would like, the entire community identifies with our mascot logo. And it's something that, it goes beyond just athletics. You consider yourself a hand tiger, whether or not, you play sports, and everyone likes paw or whatever. So, since we're looking at that and we know that we are going to be changing it, before that committee is actually formed, I feel like we should have the policy in place so that everyone knows what to expect. And I would expect, I think, also that the athletic director should be also a sitting member of the board, but perhaps a non-voting member, just like the chair and the superintendent. But that way he has full input. But then those that would be voting on this committee would be like coaches and teachers and even athletes or students and, a board member or two, just to get,
So the real
parents.
question is not, do we want it to be as developed a procedure as the other, as a complete parallel, as much as the question may be better phrased as, do we want some stakeholder input?
I think we definitely want.
Process for
stakeholder input.
stakeholder
I
input.
mean, I know the AD now does, as he was talking about in the committee. I just want to make sure that we have a policy in place so that, God forbid this happens again, knock on wood, that we know how to do it, and that it's certain that, if you leave it, like, if you leave it up to one person to sort of stop the committee, right, then you could sway the vote any way you want it, right? And I'm not saying that anyone's going to do that now, but, in the future, who knows? So I think it's just as important to have the athletic mascot logo be just like getting a new name for a facility. It should have input from all stakeholders. That's my personal opinion, but
So your opinion is it rises to the same level essentially as naming a school in terms of the way the district markets itself?
I do, because I think just like how Guilford recently had to change their logo, they had to change their entire mascot, right? And name. So, I know that definitely got input from the community, they had a vote, etc. But when it came down to the actual logo, and I'm not sure exactly how they did it, but they came up with two distinct logos for their, grizzly bear. And then after that, when you were talking about, okay, baseball team versus tennis team or golf team, they had the AD actually approved certain
Variation.
variations of it. It stayed within the same format, but maybe you added, you know, the baseball bats or the golf clubs or whatever. And I feel like that's under like the AD's, I would see it as that's the AD's,
Jurisdiction.
yes. But the actual logo itself should be community input.
I would worry that somebody could make the case that that's changing the logo, adding tennis rackets or fencing swords or the pink ribbon for breast cancer awareness month. Like I could see somebody not on this board, but like somebody saying, you changed that logo, like you've added to it or you know, or taken something off it. And so that's where I think when I think about this, like I would think if we were changing the mascot from tigers to something else, that's huge. Like that's bigger than naming a school in some ways, you know, like I would see that and I'm not planning on touching that. I also feel like I have clear direction from the board to clean up and the AD picked up on this himself and you know, this was something we've been working on for a little while now is the athletic globes. Like it was a little bit kind of free for all before. And so I know he's working on branding, he's gonna launch a committee, things like that. What my preference would be is that you know, if we were changing the mascot, that's a board direction policy, but we would stay out of kind of the logo piece. But my thought is that through that committee, we're coming out with a tiger paw and some type of action tiger different than the action tiger we have now.
Well, I think the tiger paw should be different as well.
Than what we have now.
Just a little more of a generic paw versus looking exactly like a different paw.
Because I think there's so many different paws, like I think that's very different. The action tiger is clearly from a college, we know that,
Yes,
but the
paw is
was-
clearly from another college.
It
like
was-
the scar. It's clearly, I mean. you
but
can
it's
tell
also
the
tilted
outline.
differently too. And I think you look at, there's lots of schools that use a paw, lots of high schools that use that paw, similar.
But just because someone else does it, doesn't mean.
I'm not saying that, yeah,
Right,
I don't think it should be at the same, I think it's very important, consistency and our look is important of what our logo is. I don't think it should be to the same level as naming a building, because that really is set in stone. We're not going to change that unless there's some tremendous reason why. Whereas a logo, that to me is like marketing and it might need to be freshened up in 5 or 10 years as graphics change and what people appeals to them visually changes. Like that to me is more graphic and aesthetics, and I think that.
I don't think people really
need
change
to have that
logos, though.
flexibility. They do all the time. That coat changed several times. I mean, they do, like it.
I guess my argument to that would be, we didn't have a policy in place and look at the logos that we're using now that are essentially infringing on registered trademarks.
Well, we should have I feel we should have a conversation about that, and we should have certain expectations, because I agree with you on that. It shouldn't be a free for all that, you know, because I've seen it happen myself. People be like, where'd that tiger come from? I mean, I've seen
Yeah.
it over the years, and you know, and it's just maybe a kid or a parent finds it and wants to use it. So there should be a little bit more of a formal process, but I don't think it should be like naming a building and we have to get involved every time they want to, you know, have the tiger with a tennis racket or doing a dance or whatever they want to do with it.
I mean, I would even go as far as to say, like, it would be nice to have someone in our community actually design the logo so that we know it is original and we can actually say it is ours and know that it's not copying anyone's.
I mean, I think that's fair. I think like it wouldn't cost a lot of money or a lot of time to say,
I'm hoping for a donation.
well, we love this paw print, but it's been, concerns have been raised that, you know, maybe it's somebody else's paw with the scar in it or the tilt or whatever. So that's our input. We love this. Can you give us a different paw?
I think there's a distinction between aesthetics and intellectual property.
Mhm.
And where the fulcrum might want to be placed here is, you know, to the extent that we feel a logo may be a property of ours, of our district, to be protected, right? That, you know, maybe the board have input on that, but you know, the aesthetics, I don't know if the board wants to, you know, ought to be retaining sole jurisdiction over determining like exactly what a logo should be. I mean, I think, you know, if it's athletic logos, I think maybe, and this may not be popular with you, Diane, but maybe the athletic director should have the direct oversight. And then it just be run through the administration to make sure there are no concerns about intellectual property.
But isn't that how it was already done, and look where we are?
Is that how it was done?
Well, I mean, who decided it?
That's my understanding. They said it was before, it was just kind of picked.
Yeah,
Let's
let's
really,
look for a buffer and find one,
Yeah.
right, yeah.
And so, I mean, we can certainly, you know, ask Guilford, like how they did it and how their AD went about restricting the logo
and actually,
with some flexibility.
right, and one of the things Chris talked to us about even, you know, during his interview process was going through like a branding process and having, you know, whether it's the paw print in a tiger, and saying to coaches, you can use one of these two, like, this is what you can use, and this is, you know, the color, you know, gold that you use, you know, the number.
Yeah, little bird.
and stuff, yeah, like this
The
is,
same
right, yeah,
across the
yeah,
district.
because it's, and then.
Yeah, some are like yellow and some are gold.
Right,
It's
and then
like,
football
oh,
has their traditions, they use different, you know, uniforms and colors than are used elsewhere. I don't know that we wanna get into changing that.
Well, but I think in the same way that, you know, it used to be like Ryerson, the colors were literally blue and gold. And it was, I don't remember how many years ago that they changed it to be the same as the district, black and gold. I think there's, you know, something to be said about having something unifying within the
I
district,
agree,
regardless of the level of what you are in the school, whether you're, you know, K to 12, it should be very similar, if not the same. And so in the same way that we unify the black and gold across the district, you know, I feel like the logo should be the same way. And I think there's just way too much variety. And clearly we've crossed lines in what we currently have. And so in going forward, I think it's best to have rules in place. And therefore, when you go and you look into the future, when someone's like, oh, hey, I want to use this tiger, we'll be like, no, you can't, because you need approval. And this is the process that you would do it in, and if it's not needed, it's not gonna happen. And I think that that would be better to keep us out of trouble, to make sure that whatever we're using is on the up and up, and that it doesn't, you know, have any issues with current registered trademarks or anything, and it would be ours, and it would be ours for every student, you know, it would be the same. With a little flexibility in the same way that Guilford did it, where, yeah, you can put the tennis rackets on it, but it's still the same one. You're not gonna change the tiger, you're not gonna change the paw, but you could make it pink for Breast Cancer Awareness October. You can, you know, add a tennis racket, and that would be, in my opinion, you know, jurisdiction of the athletic director. But the actual logo itself, I feel, should be approved for the district by who's in charge of the district, and that would be us. Thoughts, Dan?
I agree with either process. I think that, I do like the language, the intent of the board, the change in the logo would occur frequently. And, we'll seek the advice of the superintendent.
I agree there should be rules, and I like what you said, Craig, about the athletic director said there should be branding. Like this, you know, these are colors, black and a certain PMS colors. And that's on the website, and then the logo of whatever the tiger and the paw print, it's shown like in color and shown how to use in black and white. People can download it. Like I agree with all of that, and that would be nice to have some guidelines. I just personally don't feel that it should be so rigid that it's as difficult as naming or changing the name of the building.
Well, we could make it, you know, less strict, but I still think there should be policy. So if we look
I
at
agree with that.
what's written right now for 9710 school district logo, the current wording, we can go.
Yeah, and we brought it to the board, I'm sorry.
Oh, I'm sorry for the side talk. It's what we're trying about that, right? So Dr. Cook created this.
Everybody loves that.
With that, yeah, right, with you know,
within
redone,
the
so,
board,
yeah.
and this, I think, is a very well done, aesthetically appealing.
Right, and I like it as
Unifying
well,
theme, right?
but I have heard some people don't like it.
All right.
But I mean, you're not gonna please everyone,
Right.
right? But if it's something, and honestly, you know, that is, I think, less important than the athletic mascot logo. Because that is really identifying for the students, for the coaches, for the teams, for the community, you know, everyone sees themselves like, yeah, you know.
Yeah,
The
the
Tigers,
awareness,
the
there's
pod,
banners,
yeah,
everywhere.
it's everywhere, it's, you know, it's on signage, it's on everything. You know, whereas that's like, you know, official, well, no offense, but
No, I'm not.
official logo, it's
Trust
like,
me, that's not-
it's like, you know,
Yeah.
on the flyer, or on
Right.
the, you know.
Well, all I'm saying is that the board did have some informal input
Yeah,
on this.
and my sense with, maybe this helps, my sense with the athletic logos is that the committee would do its work, they'd come out with two. And they would bring it back to the board. This was not like you suddenly started seeing it appear on, and then my intent also would be, then we're done. Like, I mean, I don't think this is something like Maureen says, we're changing too often. Like, this
Well,
is
oh,
like,
I agree, it
Yeah.
should not be changed.
like, I could. I
But there
think
should
the
be a
change-
process in place in
Yeah,
case it
yes.
does need, you know, someone crawls out of the way, we're going, that's my tiger. Yeah,
And so with that said, I mean, I could live with either outcome, like I really. I think
right, and
that-
so my other
yeah.
concern would be, and it has nothing to do with this athletic director, but let's say, you know, in the future or in the past, there was an athletic director who would be like, yeah, I'm gonna make a committee and I'm gonna, since I favor the football team, I'm gonna stack it with the football coach, the assistant football coach, and let's see, a hand parent who's got kids on the football team. And then I also support soccer, but I don't support any of the other really. You see where I'm going with this?
I hope we don't get a director like that.
But I'm saying like, that's why a process needs to be in place. That's why we have rules and regulations and policies, so that regardless of the makeup of the board or of, you know, certain things, we want it to be fair. So like when we're naming the building committee, you ask for volunteers. You guys are gonna be on it, non-voting, but you're choosing it. We're gonna vote on it tonight as a board. That's what I'm looking for. So that it's not, you know, one person who might be like, yeah, I'm gonna, you know, this is what I want and this is, I'm gonna push it through. I don't want that. I want it to be so, you know, random who gets on it. Yeah, we're gonna have, you know, like a swim coach, and we're gonna have, you know, a lacrosse player, and, you know, so that everyone feels like they have input and that their opinion matters, and then it would come to the board, you know, and if they're, and even, I would even foresee like, we could do what's the word I'm looking for, like a survey, you know, do you like it before we, you know? And let stakeholders have a vote,
We get 50% that vote yes, 50% that vote no.
but you know what I mean, like, but if you do that, and it's not like it's a binding vote, you know, it's just to show us what the community wants. And then you could say, oh, well, like, they all hate this tiger, you know, but like this one,
And
oh,
this
okay.
is really the question of the board using advisory committees from time to time that are ad hoc in nature, right? And if we're going to occasionally change the logo, we might at that juncture decide to impanel an ad hoc. That's what we're doing with the school meeting
Yes.
committee.
Right, and that's what I'm proposing for this as well.
But another question comes up as to what if we get a cease and desist letter on the logo because we didn't realize it's too much like, you know, the Clemson Tiger Paw, for example, or something like that. Not that it would be. But then how is that currently handled? When we get the cease and desist letter, I would imagine it would be addressed to the board and to the superintendent. You would probably, you know, talk to legal about it, you know, counsel. And then advise the board as to whether it's time for us to pack up and find another logo or not.
So actually, I read an article about that, and what they had said was that usually when a school district gets a cease and desist letter, they cease and desist and change it to something else, but that can be very costly, depending on, you know, what you use the logo on. But they said an option could be is you can always approach whomever owns that particular logo and offer to like buy rights to it for X amount of money, and
Yeah.
a lot of times they will do that because you're a school and like, you know, really like Madison's just a small school, does anybody really care? So I mean, there are options, you know,
Yeah, it becomes a pending litigation or prospective litigation matter that we would probably discuss in executive session.
or you could ask Clinton what they did.
What if we tried to craft a policy that referenced this one-time ad hoc committee? And that would come back, like, not put in there that every time we're looking to change our athletic logo, we're gonna do that, but we're gonna do this one-time ad hoc committee that I can work with Chris. I know we have, a board member to be on it, and then,
Chair.
yeah, bring that forward.
Because the committee as a whole, my point is, the committee. The board as a committee of the whole essentially polices those matters naturally through that process that I just described. So there is a process in place already for that type of thing. And if establishing a new committee is such an infrequent thing, hopefully,
Yeah,
then I can see Craig's point where it maybe makes sense to, let's do a one-time community, committee type of structure and on an ad hoc basis and see what we come up with, and then the board will vote on it eventually. Right?
Mhm.
Is that like?
I mean, as long as, the final say always rests with the board, and I would like a 2/3 vote of the whole board.
I think a 2/3 vote is a strong idea on this because it is a more or less permanent intended to be a permanent thing.
Yes.
And it
Well, just
should
like the name
last
from
for
our
a while.
facility, I mean, they're not gonna keep changing that.
Yeah, so
Probably.
you want most of the board on board,
Yes,
I would think.
All right,
Not
so,
2/3 is
um,
majority.
I think that we could. We could probably say that we want to rescind 9720, because that's not really, it's not really necessary or relevant.
Well, except for the only thing about 9720 that we didn't do is that. There's part of 9720 that extends beyond logos and it's about the use of board members' names. So I don't know that we necessarily want to keep that. I'm just pointing out that there's something else there besides logos that we should consider.
Yeah, I mean. The reference to the Board of Ed members' names is like, it should be in the publication, it should appear annually, and that's. Again, this is in the bylaw series, it really shouldn't be there. But that being said, I don't think it's even necessary to keep. And that's what Shipman and
We
Goodwin
gotta
found.
wonder, what is that about? I mean, is that to protect the board members or is that to ensure that board members get their name in neon lights in certain places? You know what I mean? Like, we only want our name, you can see it going either way, where some board members like their privacy and only want their name on certain things. And other board members might be like, yeah, slap my name on everything. I want it on the logo.
Well, I mean, if we wanted, we could hold off on making any movement on 9710 and 9720 until we redraft. The 9710 and then do it in one fell swoop. That sounds good. And so, so final thoughts then on wording of this, we've got like 7 minutes, so
So
let's
the
get it
new
done.
one
It's our last one.
would be, okay, so first of all, we're talking about moving it to the thousands. here.
Right, so we want to move it to
62.
to
And then-
become 1362 unless there's some other magic number that somebody wants. So that would be,
Is that short sweet one? It's only 17.
so
Correct.
the first paragraph would remain the same, the lines 6 to 10, the Madison Board of Ed, the board. Recognizes the importance of a logo as an identifier to Madison Public Schools, the district. The board shall adopt an official logo and or mascot for the district. The board shall retain final approval for all changes to the Madison Public Schools district and athletics logos mascots and shall be approved with a 2/3 vote of all board members. So I like that. I would like to keep that where it is. The next paragraph is lines 12 to 14. The logo shall appear on all documents intended for public circulation, and all official forms of communication. All uses of the district logo or school specific logos shall comply with the parameters set forth by the administration. I'm fine with that paragraph. Any comments or questions regarding those 2 paragraphs?
I wonder if we need the first sentence.
Yeah, I don't, it doesn't seem
Yeah.
like it's necessary, it's like we use it.
Yeah.
That's sort of a administration thing, so we can cross off the sentence that goes from 12 to 13. And just leave it as all uses of the district logo or school logo should comply with the parameters set forth by the administration. The superintendent is authorized to develop regulations as required to support this policy. So then, if you look at the other page that you got today. This is the part that we will have to work on about having an ad hoc committee, or we can work on, maybe Bill and I can work on the wording on that, but if anyone has any suggestions right now, feel free to air them.
Is this regarding the board of ed members names, or are you? talking about-
Anything you want, whatever you want.
Yeah.
It's just, I knew that this was gonna be
Yeah,
a work in progress, it's not something that would move on from tonight.
I feel like it's pretty close to just crossing off that line 12 to 13.
Well, I do want some sort of,
So in other words, the board, the way this is with crossing off that one line, making that one amendment. Basically, the board would have approval rights over from time to time as it may develop over time, but rarely changing a general logo. And the superintendent would be able to allow within parameters established by regulation minor additions, changes, whatever, to the logo for
yeah, but I don't think that
specific
this is.
athletic purposes or specific school purposes.
Yeah,
So
I
if you
think
look
I
at-
need that somewhere, I think we need that, because if this was just standalone, someone could say, why did you let that out?
Yeah.
So, I mean, the on the other paper, not to call this the revision, possible revisions, the middle paragraph. The board shall seek the advice of the superintendent when determining whether and how to select a new logo and or mascot. Should a committee be necessary, a member of the board of ed shall sit on the committee as a voting member. I think that's a good thing, but I think we should also say that. The chair and the superintendent should be, members of the committee, but non-voting ex officio.
All right, so we could add that into the middle paragraph on the current draft, not the current
I mean,
version.
what about the paragraph above that? It's kind of like reiterating lines 6 to 10, but in a different way.
I don't think we need anything.
No, keep it where it is, the 6 to 10.
Yep.
Okay, so
And
that,
then add, the board shall seek the advice of the superintendent and minor changes or variations as well.
Or it should be purview, P U R V I E W. Then preview.
got it. And I think just the board chair and superintendent should sit. Ex officio.
So I don't know if that's necessary, I
No?
think that might be overkill,
But adding that last line.
for the board chair and superintendent to be,
On the committee.
I think you're covered automatically,
we could be on it, right, yeah,
right?
right.
Well, yeah, because our ad hoc committee.
Yeah, the ad hoc
bylaw
committee,
says
you're
that
on it,
you're
right,
asking-
so that's,
You're covered by that.
it's kind of redundant.
Yeah,
Yeah.
It's sort of it's like
I wouldn't-
stating a statute.
I wouldn't like to, I would be, I think Mr. Farrell can.
You're gonna have to do it.
No, I think this is an athletic decision.
So we're just gonna do the board shall seek the advice of the superintendent when determining whether and how to select a new logo and or mascot, and go to minor changes or variations to the logo and or mascot graphics shall fall under the purview of the superintendent or the superintendent's designate.
So the,
So we're taking out the middle sentence between.
Should
Right,
a committee be necessary is coming out, correct?
because that's the redundant one, we just found that. to be
Well,
redundant.
no, I was saying that the board chair and superintendent be ex officio members of the committee, that's redundant, because if you make the committee. The chair makes the committee. So you're gonna be an ex
You
officio
want to
member.
make sure that the board of ed member is on the committee.
I do wanna make sure board of.
That's, yeah, definitely, yeah, that's weird.
As a voting member.
Yes.
Yeah.
So then I just feel like there needs to be a little bit more direction with this.
All right, so why don't you,
We're gonna think about it.
based on this discussion, can you, bang out
Yeah.
a new version? All right. then we can-
Come up with like a couple versions and then,
Yeah,
well, have at it.
we can think a little bit.
All right, so I just
About-
need motion to adjourn. Someone say bye. Bye.